All right, welcome aspiring barristers. This explainer is all about helping you absolutely ace the bar exams by breaking down the essentials of disclosure in Queensland. We're going to get you totally exam ready on two of the most fundamental rules you'll ever encounter, UCPR Rules 209 and 210.
Okay, let's dive right in. Here's our game plan. We're going to follow the exact logical path a practitioner takes. We'll start with the big picture, the why behind disclosure. Then we'll hit the gateway rule, see how it works for applications, define what we're actually talking about, and then wrap up with how it all works in modern practice, and of course, the key takeaways you need for the exams.
First things first, let's get our heads around the fundamental principle that underpins this whole area of procedure. You see, before you can master the rules, you've really got to understand the philosophy behind them. This quote, it gets right to the heart of it. The whole point of the Uniform Civil Procedural Rules, the UCPR, is to make sure cases are resolved justly and quickly. And that means cases should be decided on their actual merits with all the relevant cards face up on the table, not by one side pulling a surprise document out of their hat at trial. No ambushes.
Okay, so let's move on to the first critical question you must always ask yourself. Do the disclosure rules even apply to this particular case? Your starting point for that answer, every single time, is Rule 209.
Now this slide is so important because it shows you the clear fork in the road. You have to burn this distinction into your brain. If a case starts with a claim, disclosure is automatic. It just happens. But, and this is a big but, if it starts with an application, it's a completely different ballgame. Disclosure only applies if you can convince a judge to make an order for it.
So this number needs to be locked and loaded in your memory. Rule 209. It's the gateway to disclosure. If you forget everything else from this, please don't forget that number. Rule 209.
So following that logic, right? If you're in a case that started by application, your job is just beginning. You need to be ready to stand up and argue for disclosure, and you're going to need the right tools to build that argument.
And this is the real-world challenge you'll face at the junior bar. Your opponent isn't handing over the documents you need. So what's the legal basis for your argument? What do you actually say to the judge to get that order?
Well, this quote from the key case, Waratah Cole, gives you your starting point. And notice that language, suitably tailored. That is gold. You're not asking for the floodgates to open. You're asking for something specific, something targeted. It shows the court you've done your homework, and you're not just on a fishing expedition. You have to remember that name for your exam, Waratah Cole.
Now to actually build that argument for a suitably tailored order, you turn to your toolkit. And that toolkit comes from another key case, Rolliston Cole. You'll argue that your order is in the interests of justice, that it'll help resolve things quickly, that the documents are relevant and are likely to help prove your case. These factors from Rolliston Cole are precisely what you'll use to persuade a judge.
Okay, let's move to the next logical step. Let's say you've established that disclosure applies, either automatically or because you got a court order. So, what is it? What are we actually doing here? Rule 210 gives us the simple answer.
See? Rule 210 gives us this really simple, direct definition. Disclosure is just the delivery or production of documents. You might have heard the old term for this, discovery, which has its roots way back in the old English Court of Chancery. But today, under the UCPR, we call it disclosure.
Now, knowing the rules is absolutely vital, of course. But in modern commercial practice, especially if you're in the Supreme Court, just knowing the rules isn't the whole picture. There's another layer you have to know about.
So, what's the other half of the story? Well, for your day-to-day practice in the Supreme Court, it's all about the practice directions. Think of them as the instruction manual for how to apply the rules in the real world.
For your exam, and definitely for your career, you absolutely must know Practice Direction 18 of 2018. It has fundamentally shaped how disclosure is done today. And the key word here is proportionate. The days of just demanding every single piece of paper, no matter the cost, are long gone. It's all about efficiency and proportionality.
So what does this practice direction mean for you, boots on the ground? Well, first, you have to talk to the other side early on and agree on a plan. Second, you have to make sure the cost and the effort make sense for what's at stake in the case. And finally, you must use technology to be efficient.
Okay, let's boil all of this down to the absolute essentials. If you're walking into that exam room, these are the points you need to have right at your fingertips, ready to go.
Let's bring it all home. For your exam, here's the cheat sheet. The court policy, preventing trial by ambush. Rule 209, that's your gateway, with that critical difference between claims and applications. For applications, your key cases are where ta col for those tailored orders and Rolston col for the factors. Rule 210 gives you that simple definition. And wrapping it all up is the modern reality, Practice Direction 18 of 2018, which screams proportionality.
Because at the end of the day, this isn't just about passing an exam. Mastering these rules is about a fundamental duty you will owe to your clients and, just as importantly, to the court. It's about ensuring justice is done efficiently and fairly, and that is the real test.